And we're going to have that discussion because what I would do with that ticket is give it to Andrew Weissman, but Andrew Weissman doesn't need my help because he was actually there. He used to work in that courthouse. He's going to be with us leading off tonight. And so we have the guy in the room, the guy I want in the room for these sessions. But if there's two tickets, I want to get the other ticket.
I'll scout mine to you, Lawrence.
Okay, I desperately want to be there. Thank you, Alex.
You're in good hands, Lawrence. Have a great show.
Well, today, Donald Trump met his Judge Sirica. And he met him in Brooklyn. And that could mean that Donald Trump is now on a legal fast track to a very, very bad outcome to the FBI's search of his Florida residence, where the FBI found hundreds of government documents and classified documents, including some highly classified documents that the FBI found in Donald Trump's desk. In his desk. Judge John Sirica was named Time Magazine's Man of the Year in 1974 because of his handling of criminal cases involving Republican President Richard Nixon. It was Judge John Sirica who ordered President Nixon to hand over the audio tapes of the president's discussions in the Oval Office. Those tapes revealed Richard Nixon's involvement in federal crimes. Richard Nixon then resigned the presidency and a month later was pardoned by his chosen vice president, who had become President Gerald Ford. That pardon saved Richard Nixon from becoming the first former president of the United States to be charged with a crime. And tonight, that historical achievement of being the first former president of the United States to be charged with a crime seems ever more likely to become an entry in Donald Trump's resume. Judge John Sirica was appointed to the federal bench by Republican President Dwight Eisenhower, and he took down the next Republican president, Richard Nixon. Donald Trump's John Sirica was also appointed by a Republican president, Ronald Reagan. Judge Raymond Dearie, who is now serving as the special master in the case of Donald J. Trump versus United States of America, became the special master in the case because Donald Trump's own lawyers suggested his name to the judge handling the case in Florida, asking her to appoint Raymond Dearie as special master. And because Judge Dearie has always been widely regarded as a fair-minded, reasonable, and honorable jurist, the federal prosecutors in the case simply agreed to Donald Trump's choice of Judge Dearie, who serves in the Eastern District of New York in Brooklyn. And so it was in the federal courthouse in Brooklyn today where Donald Trump, who was born in the adjacent neighborhood of Queens, was told something that Donald Trump's parents never told him. You can't have your cake and eat it too. That's actually something parents have been telling children for literally hundreds of years, beginning in medieval England, where versions of that sentence were passed around in the 1500s. In 1611, the English poet John Davies put it in a way that actually makes more semantic sense than the current version when he said, "A man cannot eat his cake and have it still." Judge Dearie conducted a meeting with the lawyers of both sides of the case in his Brooklyn courtroom today, and tonight Donald Trump is probably throwing his cake. Judge Dearie scheduled the meeting for 2 p.m. and remarkably entered his courtroom precisely at 2 p.m., according to our first guest tonight, Andrew Weissman, who was in the room. That kind of precise adherence to schedule to anyone who has spent much time in courtrooms is remarkable. It's just a remarkable way to start a 2 p.m. court session, exactly at 2 p.m. Judge Dearie was quick, he was simple, he was direct. His first question was to the Trump lawyers, quote, "Is there a real dispute about the property inventory?" Donald Trump's lead lawyer today, former federal prosecutor James Trusty, spoke in response to that question for a couple of hundred words, but didn't answer it, to which Judge Dearie said, "So the answer to my question is, you don't know whether there is going to be a real dispute to the inventory." Mr. Trusty, that's fair. Judge Dearie covered some mechanical details about how most of the 11,000 documents in the case can be made available to Donald Trump's lawyers. Then Judge Dearie turned to the most important documents, saying, quote, "The government, of course, wants the classified documents off the table for the moment, at least. I understand that. We're dealing with presumably highly sensitive information. If I'm going to verify the classification, what am I looking at? Is there a claim that the document is classified that should not have been classified? Is there a claim that something was labeled purposefully classified that isn't?" The reason I ask is, if the government essentially gives me prima facie evidence that these are classified documents, and you, the Trump lawyers, for whatever reason, decide not to advance any claims of declassification, which I understand is your prerogative, I'm left with a prima facie case of classified documents. And as far as I'm concerned, that's the end of it. That's the end of it. Donald Trump's lawyers didn't think that was the end of it. They said, we're not in the position, without having seen the physical evidence and without having a chance to fully explore what these documents purport to be, to tell the court in good faith that I know I have an argument to be made about classification. To which the judge said, well, you did bring the lawsuit and make that claim. Now, in Judge Aileen Mercedes Cannon's courtroom in Florida, Trump's lawyers could get away with making statements like that. But not today, not in Brooklyn, not with Judge Dearie. Judge Dearie suggested the clear possibility that the Trump lawyers would not be allowed to see the classified documents in this case, and that Judge Dearie himself might not even look at them. Judge Dearie said, let's not belittle the fact that we are dealing with at least potentially legitimately classified information. The government has a very strong obligation, as all of us do, to see to it that that information doesn't get in the wrong hands. It's not just a matter, it seems to me, of being cleared. It's a matter of need to know. And if you need to know, you will know. That's the way I see it. If I can make my judgments without, I don't want to see the material. It's presumably sensitive material. If I can make my recommendation to Judge Cannon, right or wrong, without exposing myself or you to that material, I will do it. Before the meeting with Judge Dearie at 2 p.m. today, the Trump lawyers filed their response to the Justice Department's appeal of the case, seeking to exclude the classified documents from the special master process. The Trump lawyers, once again, classified the case as, quote, a document storage dispute that has spiraled out of control, and said, quote, the government wrongfully seeks to criminalize the possession by the 45th president of his own presidential and personal records. The problem for the Trump lawyers is that possession is a crime. Possession of these records is a crime. It is legally true that former presidents have access to many of the records that were found in Donald Trump's home. Access, but presidents are not legally allowed to take them home and own them. The Trump lawyers repeatedly played the classification game in their filing, the appeals filing to the 11th Circuit Court of Appeals, referring to, quote, the government's contention that the approximately 100 purportedly classified documents were in fact classified. But the Trump lawyers refused to say, again, that the documents were not classified. And Donald Trump's lawyers, in writing, went so far as to invite a criminal prosecution of Donald Trump to determine whether the documents are classified and whether or not they belong to Donald Trump. The Trump lawyers actually said in writing whether some of the listed property does not, in fact, belong to President Trump is a matter best dealt with on summary judgment or at trial. There are Donald Trump's lawyers in writing today to a federal appeals court saying the way to determine who should have these documents is to charge Donald Trump with federal crimes and put him on trial. After a day of Trump lawyering like today, you don't have to be a TV fiction drama writer like I used to be left wondering, if Donald Trump's lawyers secretly were working against him, wanting him to be convicted of crimes would they have done or said anything different today? I mean, think about it. It was Donald Trump's lawyers who suggested Raymond Dearie as the special master who said today that he might not even look at the classified documents before ruling in favor of the prosecution. And it is Donald Trump's lawyers who have told the special master and the appeals court that the way to find out if Donald Trump is going to claim that he declassified those documents while he was president is to charge him with a crime. They are inviting federal prosecutors to charge him with a crime. The highest priced lawyer in the room today, the one Donald Trump is paying $3 million of his contributors' money, didn't say a word, not one word. And he's considered the most competent lawyer on the Trump side. At what point does Donald Trump begin to wonder which side are his lawyers really on? Leading off our discussion tonight is Andrew Weissman, former FBI General Counsel, former Chief of the Criminal Division, the Eastern District of New York, and Professor of Practice at NYU Law School. He's an Msnbc legal analyst, and Bradley Moss is with us. He's a national security attorney. Andrew Weissman, back to your old courthouse. You had no problem getting a seat in that room. I really want to try to squeeze in there next time. You were in the room. I just want to hand it to you. Tell us what we need to know about what happened in that room today.
I was trying to figure out an analogy to convey to people how gratifying it was to be there. It must be, I was thinking about what an astronaut who's gone to the moon must feel upon re-entry to the planet and being surrounded by the familiar and the law of gravity. Well, just like the law of gravity, the rule of law and logic suddenly was applying in a courtroom. This was vintage Judge Dearie. And you really do not need to be a lawyer to understand what he was saying to Trump. He just came right out and said, look, this is a civil suit. It is not a criminal case. You, Donald Trump, are the plaintiff in a civil suit. That means you have the burden of proof. You want these documents back. Okay. You are not saying they are just declassified. You are not presenting any proof that they are declassified. So you are not carrying your burden. By contrast, the government has established, at least by prima facie evidence, that it's on its face that they're classified. Well, guess what? Case over. If you do not want to meet your burden of proof, then there's nothing for me to decide. I am not returning classified documents to a civilian. You're not getting these. And that was sort of the tenor over and over again during this court appearance. And he was saying, look, you don't have to present evidence. That is entirely, if you have strategic reasons why you don't want to present evidence, that's fine. But that doesn't decide the case for me. That just means you have not met your burden of proof. So it was just a very clear, logical thing that, of course, should have happened in Florida with Judge Cannon, as you pointed out, that those were not the rules there. And these were just very logical questions that were, frankly, impossible for the Trump team to answer. And the closest, which was really, closest really to Judge Dearie being somewhat snide, was when Jim Trusty said, well, it's a little premature to ask us that question. And he said, and yet you brought a lawsuit alleging it. Right. I mean, that was where he was like, that's not the way this works. I mean, you were the one who came forward and wanted to bring a lawsuit. So you have to have proof. It doesn't work. It's not Alice in Wonderland, which is where we were in Florida. So this was not a good day for the Trump team. And then finally, Judge Dearie, who many people said might be slow. I never thought that was going to be the case. And he had just this wonderful phrase where he said that it's going to be important for everyone to act with responsible dispatch. And he had proposed a 4-week timeline from beginning to end. He's going to hear from the parties. And then the next thing we can expect is a scheduling order from him. But it's going to be well in advance of the November date, because he clearly doesn't think this is a complicated issue.
Yes, and Bradley Moss, the Trump lawyers were basically asking the judge to slow down in every way that they could. But you were able to predict what was going to happen today in this courtroom, because there's a big difference between predicting what happens in this courtroom and what happens in that Florida courtroom where this case began. And that is that you cannot predict stupid, but you can predict learned, careful legal scholarship. And that seems to be what we encountered today.
Exactly. And this was what, kind of following up on what Andrew was saying, this is what we always expected, that once we got this before a judge who understands the case law, who understands the national security aspects of this, they were going to look at these documents, they were going to see the classification markings, look at the Trump lawyers and say, what do you want me to do with this? It's your lawsuit. You have to either prove it's declassified or that's the ball game. As Judge Jerry said, that's the end of it. They've produced nothing along those lines because they have nothing. They have no obligation to produce those affidavits, as he noted. They can hold that back in case there is an indictment, but you chose to bring this civil lawsuit. The case law is clear. I don't like the case law. I've been beaten up on by this a whole bunch of times by judges, but the case law says what it says. And that is, if you want to be able to override those markings, you've got to have proof of declassification or official disclosure. You don't get to hint at it and then just hope someone thinks the other way.
Let's listen to the Brooklyn cheer that the Trump lawyers got outside the courthouse today.
Indict Trump! Indict Trump! Indict Trump! What are you waiting for? The worst lawyers in America!
Andrew Weissman, that wasn't too rough by Brooklyn standards.
No, but one thing I do think it's important to note, which you don't get from the cold record, is that Judge Dearie today was unfailingly polite to both sides. There was real decorum in the courtroom, and you really had a sense of adult supervision. Somebody where there just was really no acting out, with one exception where Trump's lawyer, Jim Trusty, went on a diatribe trying to say that the National Archives is a politicized institution and somehow made them responsible for the Sandy Berger criminality, which, they were a victim of his crime, not a perpetrator. But other than that, where Judge Dearie politely said, I think you're painting with a broad brush, this was a really civil discussion. It was really clear that there was somebody at the helm. And that's, just as I said, that's vintage Judge Dearie. I think we can expect that from beginning to end. And I think that we're going to see this in not too long in the future as something that we look back on and say, thank goodness that there really is a wonderful member of the federal judiciary that oversaw this.
And actually, I found that his politeness did come through in the transcript, and his patience. And his speed. It was an incredibly quick session, and the only thing that inflated the time was the amount of bloviating that Jim Trusty, the Trump lawyer, did, which the judge allowed him to do as long as he wanted to go. And then when he would finish, Judge Dearie would just quickly move on. Brad, there's a point that is made by the Trump lawyers in their appeals brief where they note that the government says the materials were stored in an unsecure manner, and the Trump lawyers say in writing, this is simply irrelevant. Bradley Moss, is that irrelevant?
No, it's absolutely irrelevant, and specifically relevant in the context of the Espionage Act, the provision that is cited in the search warrant. The entire issue is the willful retention of information relating to the national defense in an unauthorized location. Anywhere that is not an authorized secure facility by the U.S. government is, right there and then, an unauthorized location. I don't care how many locks you put on that thing in Mar-a-Lago. I don't care how many cameras he's got at Mar-a-Lago. It's not designated by the U.S. government as an authorized location to store classified documents or information relating to the national defense. That's the ball game. That's the provision right there. It's not an authorized or secure location.
Andrew Weissman could not be more jealous of where you were this afternoon. And thank you very much for being here tonight. Bradley Moss, thank you, as always, for your expertise in these matters. Really appreciate it. Thank you both.
You're welcome.